Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about what you should do if your hearing takes an unexpected turn. And what I mean by this is as follows. When you're preparing for your hearing, you're going to look at videos like mine. Of course, you're going to talk to your lawyer, which is the most important thing to do. You're going to do some reading, and you're going to have some idea of what to expect. Perhaps your lawyer will talk to you about the particular judge in your case and what to expect from that judge. But what happens if you get to your hearing and you get a different judge? So the judge you originally were supposed to get is sick and you get a different judge, or you have a brand new judge who holds hearings in a very different way, or your judge is in a very strange mood and doesn't ask you questions that you're expecting, or you have a judge who's just off the wall, and there are a couple of them out there, who has just a completely different way of analyzing cases, and you are nothing you've been prepared for is anything close to what's happening at the hearing. And I've had that happen to me a couple of times. It's happened several times where I get there and the judge that was supposed to be there is not there. I had it happen a couple of times where the judge was just wanted to do things very, very differently. And you got to think on your feet. And if, as a claimant, the other thing you got to be concerned about is, let's say you hire a national law firm or one of these large firms, or a non-attorney rep or whatever, and the attorney or the rep shows up and they're not prepared. They don't know what they're doing. This is your hearing. You've only got 45 minutes to convince a judge that you are disabled, and your lawyer may not be ready for that, or not prepared, or not really know what to do. Which obviously is why you want to be real careful in choosing a lawyer. That's a topic for a different day. But in any case, let's just say that you're in a hearing and things are just going completely different than what you expected. What should you do? First and foremost, you don't want to get rattled. You got to remember the main issue in your case, and this is the main issue in any Social Security disability case, and that is, does the medical evidence show that for the relevant time period, the relevant day, your onset date, you did not have the capacity to perform a simple entry-level kind of job? That is the only issue you want to focus on. And no matter what else happens, you want to keep that main issue in mind, because that is the threshold issue. And if the judge turns you down and you've created a case that talks about your work capacity limitations, you got grounds for appeal. But no matter what happens, whatever the judge asks you, you want to relate it back to problems you would have being a reliable employee at a simple entry-level kind of job. You always want to be very, very specific and stay away from not very much, and not very far, not very long, things like that. When you talk about your limitations, and you always want to do that, talk about your physical and mental limitations, try to put time and distance into it. How much, instead of saying, I can't lift very much, I can lift no more than 5 pounds. A gallon of milk, which is 8 pounds, would be a real challenge for me. I can walk maybe a quarter of a mile and I become so exhausted I have to stop and sit down. The more you can do that, you're protecting yourself, because the record shows you've given very specific answers to those questions. Even if the judge doesn't ask them, you want to try to get that stuff into the record. How long you can concentrate, how long you can focus, how often you have crying spells. The more you can quantify with numbers, time, distance, pounds, the more you can do that, the better. Even if the judge doesn't ask you, you want to get that in there, because that would be something that will protect your interest down the road. You always want to be prepared for certain background questions, and don't struggle or waste time with things like your work history, or the medications you're taking, things like that, or maybe even dates of surgery. You should have that. And if you want to have it written down and bring it in as a little summary for yourself, go ahead and do that. But that background stuff should not take up a lot of time, and you can hurt your case if you don't know it. Judges just expect you to remember where you worked and when you worked, and so there's no reason not to have that all in front of you. But that would be, again, something that you can, if the judge isn't asking you, you got it in front of you, you can bring it in. You always want to have the right attitude, and that is, you don't want to be here. You'd rather be working, and you can talk about how working was fulfilling for you financially and socially and just emotionally. Those are issues that I think are relevant to every case, even if the judge doesn't ask you about it. You want to make sure you know what the diagnosis is. What are the doctors telling you is wrong with you? What is the prognosis? What are they telling you? What kind of tests have you had? And again, what kind of activity limitations that you have? Sometimes you as the claimant have to kind of take control. And again, it's pretty rare, but you need to know the big picture. And if you sense, your gut tells you that your lawyer does not know or is not asking the right questions, the judge isn't asking the right questions, you want to get that stuff in there. Again, mainly information about your work capacity and about your ability to be reliable at a simple entry-level job. The more you can do that, the better, even if nobody asks you. So that is how to prepare yourself mentally for a case. Again, even in situations where you're not specifically asked about these things, you want to get them on the record. And if you get the sense that either your attorney or the judge is really not focusing on those things, you want to make sure you get those in anyway. So I would say, of course, listen to your attorney and rely on your attorney. But if in the hearing you've got to pivot and sort of just make sure that you get the right information to the judge, do that. Like I said, you've only got 45 minutes. And if you lose at your hearing, you got to go to the appeals council, which will take 2 years, and the approval rates for a remand is going to be about 10% or less. So the hearing is your best shot to do it. So again, don't get rattled. Just go forward with what you've prepared in your own mind to do, and you'll be just fine. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook. Leave me a comment. Let me know, has this happened to you? What do you think you would do in this type of situation? Subscribe to my YouTube channel and click the little bell so that you will get notification of all new videos that have come out. Visit my website at ssdanswers.com. You can download my Secrets to Winning Disability Survival Kit delivered by email. I'm up to, I think, 30 installments at this point, and I keep adding more to that. And if you're not already represented, you'd like me to review your case, I can do that as well at ssdanswers.com. There's a form to request a case review. So I hope you found this useful. And again, my name is Jonathan Ginsberg, and I do wish you well. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.